Welcome everyone to our panel and special welcome to our audience from around the world today. I'm joining you from the city of Newcastle in Australia, and my name is Amy Maguire. I'm an Associate Professor in Human Rights and International Law at the University of Newcastle School of Law and Justice, and I'm privileged to serve as a co-director of our recently established Centre for Law and Social Justice. As we begin this event, I'd like to pay my respects to the Awabakal people, the traditional owners of the lands from which I join you today. I acknowledge elders past and present, Aboriginal and Torres Strait Islander traditional owners across Australia, and First Nations peoples joining our event today. I recognise that sovereignty over these lands was never ceded, and the Centre for Law and Social Justice endorses the reform agenda that was put forward in the Uluru Statement from the Heart. To give a little background to tonight's event, the Russia-Ukraine war escalated, as we all know, in February 2022 following Russian aggression against Ukraine. However, the beginning of this conflict dates back to 2014. Since this year's escalation, the world's attention has been fixed on the conflict. And since the events in February, Ukraine has lodged a claim at the International Court of Justice, or the ICJ, and it's been investigating and prosecuting atrocity crimes at the domestic level as well. The International Criminal Court, which you'll also hear referred to as the ICC, has initiated an investigation into the ongoing commission of alleged international crimes. Our panel today is made up of experts working on issues connected to the Russia-Ukraine war, and they'll focus on two areas. First, the recent case initiated by Ukraine at the ICJ, which is known as allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, or Ukraine against the Russian Federation. And secondly, accountability efforts for the alleged international crimes committed during the Russia-Ukraine war from international criminal law and international or Ukrainian domestic legal perspectives. Our webinar will run for 1 hour and 15 minutes. I have some pre-prepared questions for the panel, and each panelist will speak for roughly 15 minutes. We don't have capacity for a Q&A function at the end today. We hope today's discussion will be of great interest to all of the people who are joining us, from legal scholars to practitioners, policymakers, and others. This webinar will be recorded and posted on our website, and we encourage you to share the recording with anyone you believe will find it of value. As co-director of the Centre for Law and Social Justice, I would like to give particular thanks to our postdoctoral fellow, Dr. Aloka Wenagasuriya, who has designed this webinar and secured the contributions of our other wonderful panel members. I myself am engaged in some research relevant to the ongoing war in Ukraine in relation to the MH17 atrocity and also the human right to conscientious objection. So I feel very fortunate to have the opportunity to chair today's discussion. And it's my pleasure now to introduce our panel. Firstly, Dr. Anton Kurenevich, who is the Ambassador at Large for the Ministry of Foreign Affairs of Ukraine. Anton is a Ukrainian lawyer specialising in public international law, humanitarian law and international criminal law. He is the agent of Ukraine before the International Court of Justice in the case against Russia that was launched this year. And formerly he was the permanent representative of the President of Ukraine in the Autonomous Republic of Crimea. Welcome, Anton, and thank you for being with us. Next, Juliet McIntyre, who is a lecturer at the University of South Australia and a PhD candidate at Melbourne Law School. Juliet is a recipient of the Law Foundation of South Australia Fellowship and has extensive litigation experience in public international law, including before the ICJ. Her research focuses primarily on public international law, particularly international courts and tribunals. Welcome, Juliet. Thank you. Next, we have Dr. Gayane Nuritsanyan, who is an Associate Professor of the National University of Kyiv, the Molya Academy in Ukraine, and a postdoctoral research fellow at the UIT Arctic University in Norway. She specialises in human rights law, international criminal law and the settlement of international disputes, and has previously worked as a lawyer at the Council of Europe and the European Court of Human Rights, and as a visiting legal professional at the ICC. Welcome and thank you for joining us. And finally, Dr. Aloka Wenagasuriya, who is a postdoctoral research fellow at the Centre for Law and Social Justice at our university, and a current visiting researcher at the Centre for European and Comparative Legal Studies at the Faculty of Law in the University of Copenhagen in Denmark. Aloka's current research focuses on accountability avenues for alleged atrocity crimes committed during the ongoing Russia-Ukraine war. And Aloka's former PhD project investigated the impact of the ICC in Ukraine and Georgia. Their research interests lie within the fields of international criminal justice and public international law. Welcome and thank you very much, Aloka. Anton, I'd like to start the questions with you, please, and give a special thanks because, as I understand, the conditions at the moment where you are very challenging, and we really are very grateful for your presence tonight. Could you start by telling us, please, how Ukraine's recent case at the ICJ under the Genocide Convention differs from its earlier case?
Yeah, well, good evening to everybody who is present today on our webinar, and good morning from Kiev. It's roughly 10 a.m. in Ukrainian capital, and of course many thanks to the organizers of this event because it's important for us, of course, to talk about our, not only our, but global efforts to bring accountability and justice in relation to crimes committed in and against Ukraine, and in relation to violations of the international law committed by the Russian Federation. Yes, this morning, it's a second Monday in a row when our business week starts with massive attacks by the Russian Federation. Last Monday, it was an important, I would say, unfortunately, missile attack on the downtown Kiev. And today it is another attack by the drones, again, on the central part of the Kiev. So yeah, now being in the office in the downtown Kiev, maybe it's not the safest place on earth, but we need to do our job, and we need to continue do the job in order to bring Russia to responsibility, whatever the circumstances are. So of course, for us, for Ukrainian government, it was important to react on the beginning of the full-scale invasion of the Russian Federation, which started on the 24th of February. And before this date, we, of course, on the daily basis followed all the events which occurred in Russia. And we were actually understanding that everything might happen, especially after the so-called recognition of some parts of Donetsk and Lugansk oblasts as so-called independent republics, and the relevant speeches pronounced on the 21st of February. We understood that really the case might be that there may be the invasion of our nation by the Russian Federation. And we, of course, tried to see how legally we can support efforts by our military, which do a great heroic job on the battlefield. We as diplomats and lawyers, we understood that, of course, we cannot be so effective and impressive as our Ukrainian armed forces, but that we need to do whatever we can in order to make it possible that law matters and that Russian Federation is brought to responsibility. So we try to analyze each and every option and to see how we can use international courts and tribunals in order to bring Russia to responsibility. And that is why in preparation, if we may call it, to this full-scale invasion, we saw a lot of emphasis, in particular by the Russian president and by his closest, I would say, counterparts, a lot of emphasis on the issue of so-called genocide, which I would pose like him, was committed by Ukraine in Donbass for 8 years, starting from 2014, and that this alleged genocide committed by Ukraine was one of the reasons why the so-called recognition of independence on the 21st of February took place, and then was one of the reasons why this full-scale invasion of Ukraine happened. And Putin himself, he talked about this both on the 21st, 24th of February, and before these dates and after these dates. And of course, we understood that there is a very important international treaty, 1948 Genocide Convention, which is, of course, in the heart of contemporary international law, because, of course, the issue of genocide and the issue of this most serious crime is so important for all the mankind, for genocide not to be committed in any part of the world, in any country, by anybody. And we saw that really Russian Federation does not stop in manipulating and speculating with legal notions in order to try to find reasons to say why actually they started this full-scale invasion, this another element of the war against Ukraine. And we decided that we cannot let Russia continue to manipulate and speculate such important international legal notions and concepts, and that we need to bring Russia to responsibility for this. First of all, because as you are all well aware, that there were not a single mentioning of the alleged genocide committed anywhere in Ukraine before 24th of February, not a single mentioning in any kind of document, either produced by international intergovernmental organization or human rights NGO or official governmental position, whatever. And we decided that really this case shall be brought and must be brought before the International Court of Justice for the Russia to understand that manipulation and speculation is not the way how this should be done, and for the international community to see that the Genocide Convention is a value and the notion of genocide is a common legacy and heritage of international community, and one state cannot manipulate and speculate it. And of course, we also do see that this our application is another element of the process which we call lawfare. So when we say that our heroic Ukrainian armed forces wage war on the battlefield to win the war against the aggressor state, we lawyers try to be as effective as we can be in courts and in tribunals with our lawfare against the Russian Federation. So of course, this case differs a lot from the so-called big case, how we call it between ourselves. The case concerning the alleged violations of Convention on Elimination of All Forms of Racial Discrimination and on suppressing financing of terrorism, because this case is about manipulation and speculation with one of the core values and one of the core concepts which are now part of general international law.
Thank you very much for that answer. And it leads me to think about prior cases that have been taken in relation to the Genocide Convention. Of course, in those, the argument has tended to be that the respondent state is actually committing genocide. And can you tell us a bit more about the innovation involved in your argument in this case?
Well, actually, we really think that this case may be called innovative one. And we heard this many times from our international partners, because yes, this is the first time when the Genocide Convention was invoked, not with the issue of international legal responsibility of a state for committing genocide, but for violations of Genocide Convention in particular, which are about speculating and manipulating with the concept of genocide and actually illegal use of war, illegal use of force on the basis of allegations of the genocide by a third state. Because as we all know, Genocide Convention doesn't include the right to use force as a remedy when one state considers that another state commits genocide. And so this innovative approach really means that no state in the world can misuse in such a harsh manner the concept of genocide. Because if there will be other instances when the concept of genocide officially is misused in such a manner, then the concept itself gets threatened. The concept itself gets underestimated and being put under the question. So that is why, of course, as I mentioned, for the time of 24th of February, there was not a single document about a genocide committed anywhere in Ukraine. And so we could not start a dispute by saying that genocide was taking place, but it was not our goal. Our goal was to say that actually Convention of Genocide doesn't let state parties to act in such a way and to recognize something or to start using the force because of some allegations of genocide. And now, since we are now in the 7th, I think, months already of this full-scale invasion, now I do really see that Convention on Genocide is not an easy treaty when we talk about the state responsibility, in particular in the International Court of Justice. It is very, very hard, and we see this from the cases which were before, starting from Bosnia and Serbia and all the way forwards. I think we will see this also in the recent cases which are now pending in the ICJ, that it is not so easy to prove states' responsibility for actual commission of genocide. So maybe whenever we talk about actual commission of genocide, it is more appropriate and more convenient and more effective to go to courts which deal with individual responsibility. For instance, to the ICC, International Criminal Court, or to the national courts, which can also adjudicate the cases on genocide. So I do believe that when we talk about actual responsibility, individual track might be really more efficient one than the track of state responsibility. And I think jurisprudence shows us this. But our case, as you mentioned, is not about actual commission of genocide, and we didn't change the plot. We didn't change the subject. Though some of the experts were asking us whether we will change the subject, whether we will change the subject matter. I mean, by adding the question of actual committing of genocide, but we haven't done this, and I think that we did the right thing. First of all, because again, it is not a case about the actual commission of genocide, but about the violations of the Convention of Genocide, in our case in particular by the Russian Federation. And also, I think that it is also important to mention that we already had a very good order on provisional measures with very, very good wording, which we really are very happy with. So that is why our case is remaining case allegations of genocide. And since we see the support from international community, from our international partners in gaining, I think it's now around 20 of interventions into our case from different states, from different parts of the world. So I do think that our strategy was a right one. And now this allegations of genocide case looks like it's not a case of Ukraine versus Russian Federation. This is a case of Ukraine plus civilized international community against the grievous violator of international law of our times.
Thank you very much, Anton. I think everybody on the webinar will have found that really enlightening in terms of distinguishing between what you have sought to do with this application and what other cases around genocide are seeking to do. Looking to the future, can I take your meaning that you would anticipate actual allegations of the commission of genocide being pursued more in the international criminal law sphere by Ukraine rather than before the ICJ?
I think that as of now, we may say that we count more on international criminal law and national criminal law in relation to individual criminal responsibility for the acts of genocide which we now see in Ukraine. And our position is as follows, as that really, if the International Criminal Court does see that some behavior, some conduct might allegedly be genocide, if the actus reus and mens rea of genocide are satisfied, if we have this dolus specialis, special intent, then I think that the ICC shall act. And in general, I think that the ICC itself wants to be active in relation to the situation in Ukraine, because ICC understands that the world is following and that the world is looking how the international criminal justice institutions do their job. In particular, of course, the International Criminal Court as the main and principal organ here. But also I think that for national courts, because of course, as we are a state party to the Genocide Convention, we have a separate crime of genocide enshrined in our criminal code of Ukraine. It is Article 442. And we are in permanent contact with our investigators, with our prosecutors. There are already opened investigations into the alleged genocide acts committed by the Russians in the territory of Ukraine. And we are very frank with our investigators and prosecutors and international partners, so that if prosecutors and investigators do see that the alleged genocide might have been committed, that they may find the this proper dolus specialis in these particular investigations, then they should move forward with this and should keep this working. Of course, the problem of the crime of genocide, when we talk about individual criminal responsibility, of course, securing this existence of dolus specialis, because you need to get to the head of that Russian soldier who committed something in Bucha, in Irpin, or in Izium, and then try to prove that this is not just a war crime, a single war crime, if I may say so, but this is a genocide with a special intent to destroy Ukrainians in whole or in part. But I do think that it might be rather easily proven when we talk about the forced deportation of Ukrainian children to the Russian Federation. I think that this might be a part of genocide, actually. And the numbers of this are really appalling from different regions of our country. And also, I think that something which is very obvious is the issue of public incitement to genocide. Maybe not for the ICC because of the gravity and mass atrocity things, but when we look into Russian state-owned, governmentally controlled media, for instance, RIA Novosti, which do have articles what Russia should do with Ukraine, or the beginning of Russia and the New World Order, which actually call for the destroy of Ukrainians in order for Russia to reign the world. I think that public incitement to genocide might be secured there in case if the investigators and prosecutors' work is done professionally and efficiently.
Anton, thank you so much. You've brought so much insight to us in such a short period of time. Of course, you're very welcome to stay, but I just wanted to flag that you may need to leave us because of the conditions in Kiev, and I wish you safety and thank you very much for everything that you've shared with us. Juliet, if I can come to you next, and my first question goes to something that Anton mentioned in passing, and that is the unprecedented rate of Article 63 interventions in Ukraine's application to the ICJ. Can you tell us a bit about what those interventions mean and what their importance is to the case?
Yeah, absolutely. First of all, before I get into that, I just wanted to say thank you very much for having me on this panel. And it's a real honour to follow Anton. And I certainly hope that he will correct me if I make any missteps in discussing his case. Look, to my mind, the sheer number of interventions is 21. I counted today, 21. And the first and clearest signal, and in some ways the most important, is the symbolic communal condemnation of Russia. So each of the interveners wants to stand before the court in its own name as a sovereign state, rather than just as like a signature on a joint petition, and show clearly that they stand with Ukraine. So in this sense, the court is a theatre, and that performance of solidarity is really important. And I think it ties into what and reinforces what Anton was saying about the purpose of the case, you know, upholding the integrity of this convention that's so foundational in international law. So that's the first thing. In terms of the actual arguments that are being put forward by the interveners, to my mind, the most important one actually relates to the court's jurisdiction. I can't say, honestly, that jurisdiction from day one of the case was indisputable, slam dunk. And I think that ties into the innovation of the application. The fact that 21 states have intervened largely to urge the court to accept jurisdiction, I think indicates that there was some doubt about whether it might have proceeded further with the case. However, having said that, across the board, there's absolute unanimity in the interventions that Article 9 of the Genocide Convention grants the court the competence to adjudicate upon disputes concerning not only the commission of acts of genocide, but also covers non-violation complaints. So the alleged question of the fulfilment of the terms of the convention. And a number of the states intervening also make the point that the term dispute is sufficiently broad to encompass questions of a disagreement over the lawfulness of the conduct of an applicant state. And so this is in essence a question of whether or not the court has jurisdiction to issue what we could call a negative declaration of compliance. So in other words, saying, yes, Ukraine has always consistently complied with the Genocide Convention, that, you know, Russia's claims are baseless. And it seems likely that they can. I mean, a declaratory judgment simply pronounces upon a legal relationship. It doesn't have to contain any kind of order that can then be enforced against anyone. And so it can be a declaration regarding the absence of a legal justification. And so therefore, I think that despite the fact that Russia's now filed preliminary objections, I think it's very likely that the court is going to proceed to the merits. And I think in part that's going to be because of this overwhelming concurrence of the interveners.
Thanks very much, Juliet. Just going further into those interventions now, can you tell us why they've mainly emanated from Western nations, and maybe reflect on what that might indicate in terms of cases such as Gambia against Myanmar?
It's a great question. So going back to May this year, there were 41 states that issued a joint statement indicating their intention to intervene. And if we look at that, it's entirely Western. You've got mostly geographically European states. You've got Australia, the US, Canada, New Zealand, some Pacific Island states, such as Micronesia, and one Asian state, that's Japan. So no African, no Central or South American states in that joint declaration. And none have intervened at this stage either. So look, on the one hand, to the extent that this war can be characterised as Ukraine standing up for Western values, that geographical imbalance makes perfect sense. Certainly the joint statement said very explicitly that the states were committed to the rules-based international order and that they were supporting Ukraine in attempting to uphold that. And I'm certainly not criticising that goal in any way. Ukraine absolutely deserves the support morally. And legally, I think that the interpretation of the convention that is offered by the interveners is correct. However, my word of caution, I suppose, is that what we don't want to see is two versions of the Genocide Convention, one sort of Western and one Southern. It's unlikely, but it's not impossible, that the court could issue somewhat conflicting interpretations in the two cases, in the Ukraine-Russia case and in the Gambia-Myanmar case. And that's where intervention in the Myanmar case could be useful. So for those not familiar with the background to that Myanmar case, the UK, Canada, the Netherlands and the Maldives have all made statements saying that they intend to intervene in the Myanmar case. And some of those go back to 2020, but quite early in the piece. Now, the UK has intervened in the Ukraine case already. Canada and the Netherlands are on that list of 41. But we haven't seen them take any concrete action in the Myanmar case. Now, there could be some explanations for that. One could be that the Gambia has already been able to overcome one of the significant hurdles in that case, which was the question of standing. And so maybe there's not an interpretation of the convention that third states need to chime in about. But that explanation doesn't cover the UK because they made their statement about intervening after the preliminary objections judgment was handed down. So it doesn't cover all of the, it's not a complete explanation. Another possible idea is that the Gambia doesn't want any interveners and might be discouraging them on the basis that interventions can add significant length to proceedings, especially if there's argy-bargy about whether or not they're admissible. But to the extent that the Ukraine interventions aren't really about legal interpretation, as much as they are about upholding the integrity of the convention, about cooperative condemnation of both abusive interpretations of the convention, but also underlying that the fact that, you know, genocide is a really significant crime that has quite clearly, you know, in my view, been committed against the Rohingya in Myanmar. I mean, the evidence there in that case is quite overwhelming. So I think these two things are quite interlinked. And so it really is something for the states that are intervening in Ukraine to, I think about the way that intervening in both cases could lend additional support to the convention and the regime of the convention overall. And, you know, maybe reflect on the fact that by not intervening in the Myanmar case, you know, those accusations of Eurocentric bias maybe have a bit of weight. So something to be, you know, cautious about, especially since the Gambia is bringing the case not in its own interest, but on behalf of the international community. So yeah, those are my kind of thoughts on that comparison.
Thanks very much, Juliet. If we circle back to the Ukraine-Russia context specifically, can you tell us what impact you think the Article 63 interventions have had to date? You know, for example, have they prompted Russian participation in the proceedings?
Yeah, and that's another really good question. Obviously, I'm not privy to anything that Russia has to say. They don't like me. They put me on a sanctions list. But look, it's possible that the interventions played a part in prompting Russia to participate. What evidence have we got? I mean, back in March, the Russian ambassador said to the court that its future participation in the proceedings was still under consideration, so they were thinking about it. It was always clear that Russia was going to object to the court's jurisdiction, whether by either continuing a stance of non-appearance, which the court always treats as an objection to jurisdiction anyway, or by filing formal preliminary objections, which obviously it's gone and done. Quite possibly, the Russians decided just that formal objections would drag the case out longer, and that in itself was a benefit for them. I also have a theory that I think is worth noting, that it is possible that Russia does see the interventions themselves as kind of an opportunity for Russia. So that is, if Russia were to succeed on the question of jurisdiction, then they'll be able to brag about their victory against the West. Look, I think that's a very unlikely end result. As I said, I think that jurisdiction in this case will be found, and I think that the case will proceed to the merits, but, you know, that's just something that they might be thinking about in the background. In terms of the impact that the interventions will have more broadly, there's a few points to be made. I mean, I've already made one about, you know, the support. But if we dig down a little bit more into Russia's objections to the court's jurisdiction, what Russia says, obviously we haven't seen the pleadings, so we don't know exactly, but they've said on their Ministry of Foreign Affairs website that the case is not about the Genocide Convention, but rather about the legality of the war. And they've also alleged that Ukraine is abusing the procedural right to apply to the court because the Genocide Convention doesn't have any pre-negotiation obligations. This is a direct contrast to the Georgia-Russia case, where the case was brought on the basis of the Racial Discrimination Convention, and the court said there are particular steps that you have to go through in bringing a case, one of which is, you know, pre-case negotiations. So obviously Russia is sort of trying that angle out again, but with a different sort of a gloss. So it boils down to an argument about the real dispute and abusive process. So some of the interventions touch on this, and so obviously to the extent that they do, their arguments will be taken into account by the court. So it gives the court more to think about. Of course, it's worth noting every single one of the interventions comes in support of Ukraine. So all of their interpretations are quite favourable to Ukraine's position, but they're not all identical either. So it does add a layer of complication. But the other thing to think about is the fact that by filing their declarations so early in the case, states have had to guess what the main points of contention are, as they haven't seen the pleadings. So it's for the parties to any case to frame the issues in the case. The interveners are only there to comment on the interpretation of the treaty. But to the extent that the ground is sort of shifting under the interveners, some of them might seek to submit amended declarations, or they might seek to submit additional declarations, or they might just change their points of emphasis when we get to the oral proceedings phase. So Austria is a good example of this. You know, they've said explicitly, this intervention is only on the question of jurisdiction. When we get to the merits, we will be submitting an additional declaration of intervention. Now, that brings me to the question of the procedure, because obviously, I hope this won't be the case, but the sheer number of interventions that we're seeing could end up backfiring. Let me explain. Even though Article 63 intervention is a right under the statute, the court still retains the power to decide whether or not the conditions of Article 63 have been fulfilled, and so therefore whether an intervention is admissible. Now, we don't know, or I don't know yet, whether Russia has objected to the admissibility of these interventions. If they haven't, then it could just be this is a non-issue. But if there is an objection to the admissibility, then it has to be said that the court's got to do, you know, it's got a bit of a, okay, I don't want to be rude to the court, but the court has a bit of a history of using very formal procedural rules to avoid difficult situations. You know, we saw a very classic example of that in the Marshall Islands cases, where they narrowed down the definition of a dispute in order to get rid of some nuclear cases that they didn't really want to decide. As judicial avoidance. So one kind of worry that I have is that the sheer number of interventions will seem overwhelming, and the court will go, okay, what's a way that we can narrow this down to the point where we can say, okay, you all have to go away. However, every single intervening state has emphasised their right to intervene at this stage of the case. And I think that it's going to be difficult for the court, in the face of this overwhelming concurrence, to deny them the exercise of this right. So it's something that I've kind of flagged as being a concern, but on balance, I think that the court is going to say, look, you've all agreed, and we all know how hard it is to get states to agree to anything. You know, 21 states have agreed this interpretation of Article 63 says they can intervene to argue jurisdiction, and they're allowed to appear. So I think the court's going to have to just run with it. If there is a phase dedicated to arguing admissibility, obviously that is going to drag out the proceedings. And then as for case management in general, if the state's intervention is admissible, it's got a right to make submissions during the oral proceedings. So it's a question of how the court is going to handle that. So my guess is that the court will do one of three things. It might pick a few representative states. How it would make that decision is beyond me, but that's one way it might go about doing things. It might group certain submissions together. Some states like Germany, Austria, Greece have indicated their willingness to work collaboratively as a group in order to make it easier for the court. Or it might be like an advisory opinion. They'll add, 3 days to the end of the hearing, and all of the interveners get 30 minutes and they're done. But, if the arguments of the parties shift in emphasis, then it could just be that there isn't a huge amount for the interveners to say. Their essential role will be that I suggested at the start. Their role will be performative, standing shoulder to shoulder with Ukraine against Russia.
Thank you so much, Juliet. You've given us so much to look out for as we all continue to monitor the case before the ICJ. And I appreciate all of your insights. We're going to turn now to you, Guyane. And I'm sorry, I feel like I might have mispronounced your name. Will you tell me again, please?
Guyane, it's
Guyane.
totally fine.
Thank you. You're taking us with the first question I'm asking here to an internal view in Ukraine. So with mounting claims of alleged atrocity crimes being committed in Ukraine, Can you tell us how Ukraine is approaching the prosecution of those crimes through the domestic courts?
Yes, first of all, I would like to thank you for organizing this event and addressing topical and important issues, as well as for the invitation to speak on this topic. So I think at the very start of the full-scale invasion, there was a realization that even with the involvement of the ICC and other states opening investigations on the basis of universal jurisdiction principle, the main burden of ensuring accountability for these war crimes will lie on the shoulders of the Ukrainian legal system. And we've already heard that ensuring responsibility for these crimes is also part of sort of our fight against Russia and our standing up for the rights and vindicating the rights of the victims who suffer from Russian aggression and the war crimes committed. And it's also important to mention that even if Ukrainian justice system is affected by the war, especially in the areas that are under Russian occupation or in the areas that are affected by the active hostilities, most of the legal system, most of the court system continues functioning. So the investigation into these war crimes started from the very first days, and we already saw first judgments, first verdicts delivered in May. And according to the information provided by the Prosecutor General of Ukraine just last week, there are 10 Russian soldiers who've been convicted for war crimes so far in Ukrainian courts. And to my knowledge, these convictions, only one of them concerns killing of a civilian, while others concern pillaging, shelling of civilian objects and civilian infrastructure. So most of this, all of these judgments concerned single episodes of war crimes, of violations, of serious violation of international humanitarian law, and direct perpetrators, so foot soldiers. And this, of course, can be explained by the availability of access to necessary evidence to mount the case, and by the availability of the perpetrators who are in custody of Ukrainian authorities. But one can also reasonably assume that it has to do something with the fact that this is a single episode of shelling or pillaging that is perhaps easier to deal with, to investigate, to prove in the court, as well as direct perpetrators, which also is easier to show the responsibility of direct perpetrator and doesn't require, for example, establishing the chain of command, etc. All these cases have been prosecuted in the courts of general jurisdictions that have territorial jurisdiction over them, except for some of them which were transferred to the adjacent courts if the security situation requires it. There has been discussion around the military courts. International humanitarian law does not prohibit trial of war crimes in civil courts as long as the same rule applies to the members of armed forces of both belligerent parties, which it does in the Ukrainian legislation. Nonetheless, there has been some internal discussion in Ukraine on the necessity to bring back military courts, which were abolished in 2010 in Ukraine. Some believe that military courts would be more competent to deal with the issues relating to serious violation of international humanitarian law. But in my opinion, and I think some of the domestic and international experts also have expressed a similar view, it will be it is much better to create perhaps a specialized branch of the judiciary that would be focused on prosecuting the war crimes. And I think this would allow to acquire more necessary expertise in a more effective way in prosecuting and trying these war crimes. Because of course, the fact that a domestic system does not have a lot of experience in prosecuting war crimes is not that unusual. In fact, it's a more common situation. And creating a specialized branch and perhaps adding an international element into it, and that has already also been suggested by many international experts, either in the form of international judges or international legal advisors, can also sort of add another source of this expertise. We can see that the prosecuting authorities or the investigators and prosecutors cooperate quite closely with international experts. There is a group advisory group on atrocity crimes that cooperating with the Prosecutor General Office, and they do it in a twofold manner. So they have a sort of a group of international advisors who advise on legal issues, who provide mentorship. And also there is a mobile justice team who is composed of international and Ukrainian experts who are deployed on the ground, for example, to collect evidence. So we see that prosecuting authorities and investigators have been quite open to international cooperation, and in fact there are special war crimes units in the Office of the Prosecutor General that were created in 2019 already, so before the full-scale invasion started. Because as you said at the very beginning, Amy, the war, the conflict and the war started in 2014, and there was a need to investigate war crimes that were taking place in eastern Ukraine and occupied Crimea. But I think there has been historically a bit more reluctance from the judiciary to open themselves to international cooperation on these issues, even though we've had in the past decade kind of a big project of spreading the knowledge on the practice of the European Court of Human Rights and on the practice on the European Convention. And there has been a lot done to educate the internal actors, the advocates, lawyers, judiciary, state officials on the human rights law, on the relevant human rights law. So I think there is already this practice, there are patterns, there are actors, domestic actors, that international actors that could actually facilitate this necessary improvement of expertise in relation to international humanitarian and international criminal law.
Thank you very much. The scale of upskilling required in this sort of shocking scenario is quite stark, and it's really interesting to reflect on what that means for the judiciary of a country and how it can respond in time in such a crisis situation. Thanks very much for telling us more about that. Would you say that there have been issues already, or do you anticipate issues in future, for example, in terms of managing the quantity of evidence or gaining access to territories that are under Russian control, perhaps in relation to conducting any trials in absentia, or indeed if there are issues with the Ukrainian criminal code itself that might need to be amended in order to support effective prosecutions in the future?
I definitely think that the large scale of the criminality poses a challenge to Ukrainian legal system, and I think it would pose a challenge to any judicial system, let alone one that is affected by the war and has to deal with the consequences of the war. And support of Ukraine with international experts, international investigators and expertise, I think is one way to deal with it. Just like was mentioned, this kind of cooperation with the Prosecutor General Office, that is very important to have people on the ground with the necessary expertise to collect evidence. But in this past years before the full-scale invasion, we also sort of developed quite a lot of expertise among non-governmental organizations that are working on collection of the evidence, but are trying to do this in a way that does not interfere with the work of the official authorities. So they use a lot of open source evidence, etc. So I think when we move to the next question about the gaining access to the territories occupied by Russian Federation, of course, it is a challenge. It's not safe for anyone from the Ukrainian side to be present or to travel there. And perhaps the open source evidence can be one way to collect information. But in my opinion, we see that the full scale of the crimes committed and is revealed only when these areas are liberated. And we saw that in Bucha in spring, and we saw this more recently in Izum, in Kharkiv region, in Liman. So I think to really see the full picture of what has been going on, it's important that Ukrainian forces gain access to these areas. When it comes to, I think it was the issue of prosecuting and trying cases in absentia, Ukrainian criminal procedural court allows it, and it's not also, as it is well known, against international human rights law to prosecute, to hold trials in absentia, as long as all the necessary procedural guarantees are complied with. And I think here, the main issue that I see is Ukrainian court system must ensure effective representation of the accused in order to make sure that these trials are in compliance with the due process and are accepted, right, at the international level by the community, and perhaps in some future by those against whom the verdicts are delivered. So I think here ensuring the compliance with the procedural aspects is very important. And when it comes to the criminal legislation, many may have heard that Ukraine has this general provision that criminalizes violations of laws and customs of war. So we don't have a list of specific war crimes that are criminalized. We have one provision, provision 438 in the code, in the criminal code of Ukraine, and all these 10 convictions that we have seen so far, they are, even though they concern different war crimes, so willful killing of civilians, shelling of civilian objects, pillaging, they all are prosecuted under the same general provision. And in my opinion, actually adopting, introducing the amendments that would contain a list of specific crimes with the elements of crimes specified would bring more clarity into this process. And there are draft laws that have been elaborated in cooperation, again, with domestic experts, non-governmental organizations. And I think that would not only bring more clarity into the process, but provide the actors, the investigators and judges with a more effective instrument of how to deal with these war crimes, how to qualify them perhaps more precisely. Sometimes it's not clear when we see that the person has been convicted, tried and convicted for shelling of the object. What are we talking here about? Is it the intentional shelling? Is it indiscriminate shelling? So I think this general provision does not work that well. So it's time for Ukraine to modernize its criminal law legislation. Another point is that the criminal code does not criminalize crimes against humanity. So it does allow prosecution of single war crimes, but it does not allow to kind of vindicate this type of criminality that has widespread and systematic nature. And when we are talking also about, for example, crimes that constitute crimes against humanity, but do not constitute war crimes. For example, about persecution, and we've heard a lot about persecution of Ukrainians, especially those who somehow manifest their allegiance to Ukrainian state in the occupied areas. So criminalizing this, including crime of persecution into the criminal court, would allow, again, to vindicate the rights of these persons and try this culpable conduct.
Thanks very much. It's striking that there are some quite significant parallels between some of these issues that are confronting the Ukrainian courts and some of those that confronted the Dutch court that is undertaking the prosecutions in relation to the MH17 atrocity. And I understand that that court plans to release its judgment next month. So it'll be interesting to see how the court finds in relation to those four accused, none of whom, of course, appeared before it. Just briefly, if I can ask you a final question. I understand that the sentences that have been delivered so far in the Ukrainian courts for foot soldiers have been quite harsh. And I wonder, do you think that they may stand in stark contrast with any potential future sentences from the ICC, which may be more lenient?
Yeah, we saw the sentences between 8 and 12 years imprisonment, and in one case it was life sentence, which was later reduced to 15 years imprisonment. And I think the first point that I want to make here is that the judges in these instances, they are applying domestic legislation that is adopted in the due process by the legislature. So the criminal court directs basically the judges that the sentence for war crimes can be between 8 and 12 years imprisonment. So they are kind of restrained by this framework. And I think that's important to know. So it's not an arbitrary process. That's what is set by the domestic legislation. But I think on overall, yeah, if we look at the sentences given by international criminal courts and tribunals, they tend to be more lenient. But I wonder if that is going to be true in future as well, because lately we saw, for example, in Taganda case, where the court applies the second harsher sentence, which is 30 years imprisonment, and Ongwan case where the sentence was 25 years. Of course, the cases differ in terms of nature of the crimes and the scale of criminality, which spanned over several years in these cases. But one will have to see what kind of case the ICC takes and who is going to be the person who is tried there.
Thank you very much. Aloka, we are coming to you as our final speaker on the panel. And so far we've canvassed prosecutions in the Ukrainian courts and earlier the current case before the ICJ. And you're now taking us to the ICC investigation. And I should mention for our attendees that you are joining us with an unfortunately weakened voice, having lost it a couple of days ago. So thank you very much for rehabilitating your voice to the point where we will be able to hear you. Can you tell us, first of all, please, how has the ICC investigation progressed so far?
Thank you, Amy, and I apologize once again for my voice. I don't usually sound like this, but this is the best I can do today. And thank you to our panelists for their excellent insights before. And I also learned so much from all three of you. In terms of the ICC investigation, we all know that it started in March this year, when the prosecutor announced that he would be initiating an investigation. And how this came about was, as some of you know, the preliminary examination into the situation in Ukraine, that concluded already in December 2020. And there, the former prosecutor was looking at alleged crimes that had been committed since 2013, since November 2013. But at that point, when the preliminary examination was concluded, the prosecutor's office didn't have enough resources in order to continue on to the investigation stage. And then we saw this escalation of the conflict in February this year. And the prosecutor made, the new prosecutor, Karim Khan, he made this important announcement where he said shortly afterwards that he intends to open an investigation. And what we saw at that point was there was this, just like with the ICJ, there was an unprecedented number of state party referrals. And here I'm talking to state parties to the Rome Statute, which is the constitutive instrument of the ICC, the International Criminal Court, that referred the situation to the court, which meant that instead of the prosecutor having to go and seek authorization from a pretrial chamber to open an investigation, he could open an investigation straight away. And there we saw 39 state parties referring and 4 others joined afterwards. So 43 state party referrals, which is phenomenal. It has happened before, but there we were talking about 6 state parties, not this number of state parties. And in terms of how this ICC investigation has progressed, we see the prosecutor on world media nowadays. There is a lot of attention on this ongoing war. But first and foremost, despite all the interviews that have been given to media, what we see is that the prosecutor's office is extremely secretive about what is actually going on. I mean, I've worked with the Georgia situation before during my PhD, and there, when the investigators were traveling to conduct interviews, to gather evidence, etc., they weren't even allowed to tell friends that they were going. And here we see the same kind of thing with the ICC as well. We see afterwards, recently, I think the 13th of October, the prosecutor said, now a team has returned from Izum and Kharkiv. But, we know that there is presence by the OTP on the ground, but we don't know exactly what it is that they're doing, except the fact that they are doing thorough investigations into proving the alleged commission of atrocity crimes. And we've heard time and time again the reference to war crimes and crimes against humanity, but not to mention, like, we haven't heard the crime of genocide being mentioned as yet, even though recently the prosecutor in a media interview gave us a little bit of a hint. He first referred to the indiscriminate targeting of civilians as being a potential international crime. And then he also referred to transferring members of a group to another group and specifically mentioned children. And there, this sort of, made me think, is this a hint that perhaps they're also investigating instances of genocide? We've seen that there has been a significant injection of resources into the ICC recently, since the escalation of this conflict and the start of the investigation. And for a resource-starved institution like the ICC, because we saw December 2020, that was what everyone was talking about. There are so many of these preliminary examinations that have been concluded, but there is just not enough staff, not enough money to initiate the investigations and then to conduct the investigative activities. And in May 2022, we saw that the Office of the Prosecutor deployed the largest ever field deployment to Ukraine that it ever had to any situation. And there we were talking about 42 investigators who were sent to Ukraine to collect evidence on the ground. And since then, the ICC has had a permanent presence, a field presence in Ukraine. And at the end of September, beginning of October, there were further members who were deployed by the OTP to the east of Ukraine that some of our other speakers also spoke about, to investigate allegations of atrocity crimes. And this has been possible due to various factors because of this coordination, this cooperation that we have previously referred to as well, because state parties to the Rome Statute, what they've done is they have started seconding national experts to the Office of the Prosecutor of the International Criminal Court. So this has injected vital resources into the office. And this came after Karim Khan pled for assistance for the court's investigations. And here we saw 21 states parties committing seconded staff, national experts to the OTP in order to facilitate the court's investigations. The OTP's investigations, rather. And in July 2022, we saw 45 countries. They pledged a further $20 million to the ICC, the Office of the Prosecutor General in Ukraine, and to other UN efforts as well. So a significant injection of monetary, a monetary contribution there as well. And In terms of the deployment of the ICC team, this has also significantly aided the process of the proper collection, the storage, and the preservation of evidence, including testimonial, forensic, and digital evidence. And Mr. Khan, Prosecutor Khan, recently made reference to the fact that they were working together with experts from other countries and teams from other countries who are on the ground as well, with the Office of the Prosecutor General of Ukraine, and also that they were assisting with some of the very and working together with the Ukrainian authorities, collecting evidence such as digital evidence, cracking phones, some of the very technical things that needs to be done. And here, the most important thing is communication and coordination. Of course, there has been an influx of actors who are now investigating, who are on the ground, not just the ICC, but NGOs as well, and investigators from other states. So what we'll see is that communication is key here, also to stop things like over-documentation, and also to make sure that we have this viability of the testimonies and the evidence when it comes to that crucial trial stage at the ICC, because that's a very technical issue, but these are things that we'd have to think about as well going forward.
Thanks very much. And with all of that in mind, what would you say are the prospects of arrest warrants being issued anytime soon, or trials commencing at the ICC?
Well, once again, secrecy. But this is a vital aspect as well to any criminal investigation. You don't go around broadcasting, this is what I've found, voila, this is what we've unearthed, we are going to go and arrest this person immediately, things like that. So the prosecutor has indicated that teams from the OTP, a team from the OTP has been in various areas, that they're not just focusing on Bucha, they're not, and Irpin, they've been to Kharkiv, to Izum, etc. And in terms of the arrest warrants, the prosecutor has gone and said that, hasn't said anything about when they will file the formal charges. The prosecutor has stated that the court would wait until the evidence is sufficient. And Prosecutor Khan has also said that they're moving forward, that they're focused, but that they will make announcements at the right time. And what that right time is going to be, we don't really know as such. However, there have been other indications. For instance, the EU's Justice Commissioner has stated that in conversations with the prosecutor that according to the Justice Commissioner, he suspects that the first cases should already be on the International Criminal Court's table, most likely before the end of the year, and that the first trials should start soon. And some international experts have even said that they expect to see the first arrest warrants being issued within the next couple of weeks. Of course, with all the investigative activity that's going on right now, and with so much focus on the situation of Ukraine, and with all these resources at play, I can understand that everybody wants a result like that. However, these processes take time, and we are not talking about individual instances of commission of crimes. Yes, we are talking about them, but in terms of gravity, in terms of command responsibility, etc., we're looking at international crimes here, where you have to establish patterns. You have to separate the truth from, propaganda and things that have been made up. You have to establish the correct narrative, because that's what will sustain the cases that will come up before the court. So there is the likelihood that we might see some arrest warrants, perhaps by the end of the year, and that these arrest warrants, probably because of the symbolic value. Now, the OTP has two ways of issuing arrest warrants. Either they can do it publicly, or they can do it without making it public. But I think that perhaps if and when arrest warrants are issued, they would be issued publicly, because it also has a symbolic value of signaling to the perpetrators and potential perpetrators as well in the future that, look, you commit international crimes, this is what will happen. You cannot, impunity is not an option for you. And in terms of who would be targeted, probably the first arrest warrants might be directed at sort of mid-level Russian commanders. And the prosecutor has indicated that Ukraine, for instance, if they have prisoners of war who are Russian commanders or others from the Russian military that they have captured, that it is a possibility for Ukraine to transfer such individuals to the court if arrest warrants are issued for them. And the prosecutor has also stated that, because everyone's wondering, will Putin ever be tried? And the prosecutor has said that being in a position of command, being the president, being the prime minister, that this does not absolve you of responsibility, that there is no statute of limitations, that there is no immunity if a head of state were to commit international crimes. But whether the OTP would be able to connect these crimes to Putin and then if they would issue arrest warrants for somebody like the Russian president, we are yet to see. I'm sorry. And then there's this thing about the crime of aggression, of course, for which the court doesn't have jurisdiction, most unfortunately, in this particular instance. So we just have to wait and see about which arrest warrants are issued and when.
Thank you very much. It falls to me now to close our event. The time for me has gone so quickly, and it's been such a privilege to hear from our 4 wonderful contributors today. I'd like to thank them all very much, and a special thank you to Anton, who did have to leave us a little while ago, but who was joining us from a shelter in very difficult circumstances in Kiev today. Thank you all of you for sharing your very dedicated research and your insights with us. And many thanks also to Saskia Jones, who is our project officer with the Centre for Law and Social Justice, who has managed this event and made it possible for such a broad audience to join us from around the world. And finally, many thanks to our audience today for coming to us from wherever you are and for engaging with these important issues. Thank you, and from Australia at our time, good evening. That concludes our event.